has pointed out, the judge in our demand, the demand which we are making to government, in the process of negotiation that's still ongoing, the judge, number one, will have to be a Muslim. The opponents allege that, so what if he's a Muslim? So many judges are Muslim and don't make salah. So many judges are Muslim and don't do their kalima. So many judges are Muslim and they drink wine. Yes, these might be true. But it's not a judge that's a Muslim alone. That's only step one. That's only the first of the conditions. Thereafter, the judge needs to sit, in terms of what we demand, he needs to sit with two assessors. Now, normally, assessors are merely advisors to the court. If the judge wants to go this way and the assessors go the other way, then normally the judge overrules the assessors. We say this is not good enough for us. This is not tight enough for us. Chances that this might go against the Sharia still exist. So we want the two assessors to be given full adjudicatory powers, the net effect of which is you have three judges in front of you, two of whom can overrule the other one. The other fact is that those two assessors will not be any Tom, Dick and Harry. They will be ulama in terms of our demand. Ulama well schooled in the Sharia to make sure that this falls in line with the Sharia. The other advantage hereof, in terms of what we are demanding, and in terms of which has already been granted in the existing bill, is that we do not envisage and we do not intend that people should go to court ever. You know, the best thing that can happen if there's a dispute between husband and wife is to settle it in the house. If you can settle it in the house, Allah will reward you hugely for that, because لا خير في كثير من نجواهم إلا من أمر بصدقة أو معروف أو إصلاح بين الناس. If you bring about reconciliation, then من يفعل ذلك ابتغاء مرضات الله فسوف نؤتيه أجرا عظيما. If the couple can bring about sulh between the two of them and never need to go to a court, alhamdulillah, Allah will grant great reward for that. If they cannot bring about that particular sulh within the house, then they do not go to court. If you go to court, then the judge will ask, have you gone for compulsory mediation? And you ask, what is compulsory mediation? The existing ulama bodies and other similar bodies perhaps will apply for this. They will become accredited mediators. Accredited mediators by the courts. The court will say you cannot come to court until you have tried to make a sulh, bring about reconciliation with an accredited mediator. If you reach a conclusion with that, the conclusion will simply be brought to the High Court and confirmed as an order of court. If you do not succeed, and it's possible, but chances become progressively less. If you do not succeed at this level, then in our original bill, which we submitted to government, we asked for arbitration. Arbitration is different from mediation. Mediation, you still have a chance to pull out. Mediation, you can still say, well, I don't agree. But arbitration is a semi-legal process. It's like an ad hoc court. And whatever judgment is passed upon you, that goes to court and that becomes confirmed as an order of court. And where do those judgments take place? Among the ulama themselves. The same people who have all along been adjudicating the matters, those same people will be taking charge of those matters, and when they reach a conclusion, it will simply go to the High Court to be confirmed as an order of the High Court, and that's when policing power sets in. The husband who is now recalcitrant, who is now reluctant, who still refuses to give the haqq of his wife, will be forced by police, will be forced by the long arm of the law to fall in line not with South African law, but with the Sharia. This is what this law provides for. So there will be mediation. There will be, inshallah, arbitration. In our negotiation with government, arbitration was struck off by the government. The cabinet struck out arbitration. In other words, they weren't granting us arbitration in that stage of negotiation. There is a reason for it. And that reason is not malicious intent. The reason why the government did that is that we have an arbitration act, a law on arbitration in this country. And that law says you can arbitrate anything. All your civil matters, all your buying and selling matters you can arbitrate, but matters of status, family law, marriage, divorce, custody, maintenance, those will not be subject to arbitration. We say we understand that. That is your law as it stands. But we also understand that you made the law and you can grant us exemption from that law as well. So we're demanding the right for arbitration back in order to make sure that as few cases as possible will ever reach the High Court. It will be dealt with at the level of personal mediation between the two parties, compulsory mediation with an accredited mediator, thereafter arbitration with recognized bodies, and it is envisaged optimistically that 80, 90, perhaps 95% of cases will be dealt with and will be settled in this case with the policing power that the confirmation of the High Court will provide. These are the advantages. We come, however, now to certain disadvantages, certain concerns around provisions and the contents of this bill. Now, before I go on with those particular clauses that are contained within this bill, I'd like to say that what many have seen, for those who have downloaded the document, those who have seen the document, and those who have commented upon it and pointed out certain things in it, on account of which they label it as a kufr bill. Fact of the matter is that those very same clauses are the ones that we in our submission have struck out. That we have told the government that we cannot live with something like this. This is not our Sharia. But our approach, as I said previously, is one of telling government, we don't want this, we want this out, we want this in. The others say, since that clause stands there, we cannot live with this, and therefore we reject. We don't reject, we negotiate it, because the door for negotiation is still open. What's happening now? Up to the 15th of May, you have chances to make your submission, and you don't need to be an organization to make submission, but you need to provide motivation. You cannot simply say, no, I don't support this. That means nothing to government. You have to say why. It's not just a matter of no, it's a matter of why. So simply an SMS sent to the Ministry of Justice that says no is not going to do anything. This is what the Ministry of Justice itself has said. They need motivation. The organizations are doing theirs, individuals have the right. Back in 97, 98, many people made their submissions, and all of those submissions were collected and published, and they are available to be looked at. You have 2 more months within which to do the same kind of submission. I come now, however, to some of those clauses within there that people have a problem with. The first of which is the issue of polygamy. Now we know in our Sharia, Allah Ta'ala has permitted nikah. You can marry one wife, and you can marry mathna, wa thulatha, wa ruba', 2, 3, and 4. That has been permitted. The same thing is permitted under customary law in South Africa as well. But forget customary law for a moment, and let's just see what has happened when other Muslim countries try to regulate polygamy. Some of them took steps of completely outlawing polygamy. Tunisia, for example, Bangladesh, for example, Turkey, for example, they simply said polygamy is not allowed. Any person who marries more than one wife is guilty of a criminal offense. Other jurisdictions such as Pakistan, Egypt, Syria, they place such draconian requirements in the way of the person who wants to marry another wife that all that they have succeeded in doing is to drive the practice underground. You're not going to drive the practice like you're not going to kill a practice like this simply by saying the law does not allow it. An example which I have mentioned elsewhere, which I will repeat now, is the one of India. In India, we had Hindus and we had Muslims. Now, Hindus, in their traditional law, they also had polygamy. In fact, most religions had it. And from the 1940s, 1950s, the reformers of Hindu law decided that no, this is a modern era, and we can't be like these barbarians who marry more than one wife. We're cutting that out of our system. No Hindu will, as from now, be allowed to marry more than one wife. Half a century later, in 1997, a survey was done. It was published in the Hindustan Times in 1997. They looked at Hindu society, they found first Muslim society. They looked at Muslim society, out of every 1,000 Muslim males, they found that there's about 15 polygamists. 15 polygamists. Now, amongst Muslims is permissible, and they are just 15 in 1,000, 1.5%. They went to the Hindus, they found that out of every 1,000 males, there are 72 polygamists. Even though it's not allowed under the system, they will still do it. So we say, if you start putting extremely difficult, onerous conditions upon a person, which makes it practically impossible. For example, you have to get the permission of the first wife. For example, you have to get the permission of the court. Once you start putting all of these things in place, you will not succeed in rooting out the practice. In 1998, the Customary Marriages Bill came out. It carried a memorandum with it. That memorandum says the reason why they're not banning polygamy is because polygamy cannot be banned. You cannot ban it, you will simply drive it underground. We recognize that, but we also recognize that you cannot put extremely difficult conditions. Once it goes underground, then someone suffers. It's either the second wife that's going to suffer, it's either the first wife that's going to suffer. So what we looked at the government's bill. The government's bill says you must come to court, you must get the permission from court, and you must show court that you have the ability to maintain two households. We say that if the legislature of this country is going to be fair, then they should grant us Muslims exactly what they granted blacks in this country under the Customary Marriages Act. What have they granted them? All that you need to do, come to court, show a written contract of how the proprietary regime of your household will be maintained from this day onwards, how you will maintain the justice ordained by the Quran. Not to get permission from the government, from the court, but you must reveal your intentions clearly up front, and you must show that this is how I will distribute the property between my two wives. This will make for what? It will make for a situation of openness, one of transparency, one where we do not go underground with things and we keep it all out in the open, which is exactly where Islam wanted in the first place. So we have other jurisdictions that completely ban this. We have some jurisdictions that make extremely difficult conditions. In our situation, our government has offered us the option of saying, seek permission of court. We, the United Ulama Council, say we are not going to seek permission of the court, but we will want it to be on an equal footing with customary marriages, lay in front of the court simply a written contract that shows what you intend to do thereafter, and they will then have to take the next step and the person will go ahead. I think the way we have worded it here in South Africa, the United Ulama Council submission to government, it's much closer to the Sharia ideal than what other countries have. If our government wish to enforce upon us a kufr system, if our government wish to enforce upon us an un-Islamic system, they wouldn't even have negotiated this matter with us. Elsewhere in the world, 1973 in Somalia, under the government of Muhammad Siad Barre, the man who created all the problems that Somalia is still suffering from right now. How did it start? He introduced the Muslim Personal Law Bill. In that Muslim Personal Law Bill, he says that the laws of the Quran applied back then, they don't apply any longer. The Quran says, twice to the male what the female gets. I say, says Muhammad Siad Barre, I say that law doesn't apply and we have a new system, we have a modern democracy. The ulama objected. His response was to line up 10 of them and execute them summarily. From that day, the trouble started. Somalia still haven't recovered. So if anyone wanted to force, we'd have a situation like that. I think our visitors to our country have many a times attested to the kind of liberty and freedom that we have in South Africa that others elsewhere can only dream of. This is just another example, aside from those who believe that everything that the government does is a bad thing, everything that the government does is an account of conspiracy theory. From 1995, the government has been engaging. They're still in the process of engaging. They haven't enforced anything. In fact, it is said that the previous Deputy Minister of Justice, Brigid